that are here, 2.5 hours. And I'll structure it to allow all the councils. We have split because this is going to be the biggest debate that has ever been done in this country. Thank you, Mr.
Thank you, my big cousin and Dustan Omari. You know, the Kizis and the Merus are the same. And I believe you will grant you the 2.5 hours that you want, so that when you go back home, you don't tell them ungood stories about the Meru and your cousins. Clerk, know the time. Clerk, please know the time, so that at that time, then we can proceed with our business. Council can continue.
Thank you very much, Mr. Speaker, sir. And as I said to all the members of Meru County Assembly and the citizens who are at the public gallery, my full names are Wakili Dustan Omari. I am going to lead a team to defend the governor of Meru County over serious allegations that have been put by the accusers. First and foremost, accept the apologies of the governor for her not being present today, but she's ably represented by a battery of 7 lawyers who are equal to the task. The first issue that I'll raise through the Mr. Speaker is to go back to the standing orders of Meru County and refer to standing order number 90. Standing order number 90, it is a standing order for Meru County Assembly. The import of that standing order has a bearing, and a grave bearing, to the proceedings that we have today. In the wisdom of the County Assembly of Meru, they made that law and gave it to themselves, that it shall bind the County Assembly. It cannot be run away from. It is the supreme law of this County Assembly. It has not been repealed. It has not been varied. It has not been deleted. It is currently the law of this assembly. What does it say? Mr. Speaker, sir, it reads matter sub judice or secret. And 91 says, subject to paragraph 5, no member shall refer to any particular matter which is sub judice or which by the operation of any written law is secret. We delete secret. It's no longer a secret question, it is sub judice. And the honorable members of Meru County Assembly defined what sub judice is in sub rule 2. A matter shall be considered to be sub judice when it refers to an active criminal or civil proceedings and the discussion of such matter is likely to prejudice its fair determination. The wisdom of the members of the County Assembly said they will never touch any matter that is before a competent court of law. The reasons Parliament came up to that reason is that any determination before the assembly is likely to prejudice a decision before the courts of law. And in the wisdom of Parliament, they extended it to cover both criminal and civil. These honorable members of Parliament of the County Assembly went in paragraph 3 to say, in determining whether a criminal or civil proceeding is active, the following shall apply. Very detailed. 1. 3A.
AJ Meru TV.
Magic has hit your imagination of TV. A brand new Vitron TV with StarTime's inside technology. New TV innovation with an inbuilt decoder that connects you to both StarTime's antenna and satellite signal. With StarTime's inside Vitron TV, you can enjoy over 200 local and international channels. 1 month StarTime's highest bouquet for free. Automatic system update. More benefits, more affordable. StarTime's inside Vitron TV is available in all StarTime's branches and dealers countrywide. StarTime's inside. Entertainment inbuilt. StarTimes. Enjoy digital life.
Oreigwa nkume ya Kenya Airlift Program kanyagaka no mwanka withro urina grade ya C+ gwitia kiri KCSE na second class honors kiri degree ya university. airliftprogram.com. Obisi chiaturi Royal Business Park 4th floor Njorincheka Street, Meru Town. Turingeredi mungu kurukira 0703 509 493. The Kenya Airlift Program. Passion led us here.
AJ Meru TV.
Under sentence or discontinuance, have the people charged been convicted and they are at committee prison? Did the director of public prosecution discharge them by withdrawing under section 87A? The proceedings are still on. That is a fact well known to everybody. Third, Mr. Speaker, sir, on the civil proceedings, it shall be deemed to be active when arrangements for hearing, such as setting down a case for trial, having been made, until the proceedings are ended by judgment or discontinuance. Today, before I came to this honorable house, were before the Court of Appeal. A judgment or a ruling is coming out on Friday over the same issues that are before this honorable house. Do we close our eyes? The governor has been charged for contravention of the law. The governor's allegation are an allegation of abuse of the Constitution. The governor's allegation against her are based on law. Do we ourselves close our ears from following the law? And we say we must defend the law against the governor, but the law cannot be enforced against us. Members of the County Assembly, that is the question before the Speaker and before you. Number D, appellate proceedings like the one we were today, whether criminal or civil, shall be deemed to be active from the time when they are commenced by an application for leave to appeal or by notice of appeal until the proceedings are ended by judgment or discontinued. The law, as you passed it, says an appellate appeal either from a magistrate's court or from a high court to the court of appeal or from a court of appeal to the Supreme Court binds this assembly. Now the burden on the governor is on number 4. That whoever alleges, a member alleging that a matter is sub judice, shall provide evidence to show that paragraph 2 and 3 are applicable. We shall table all the cases that are alive in court, and those cases are touching all the 7 counts that the governor is facing. That in itself, in the question of law, is a preliminary objection on the question of law. Once that question is determined, I'll pack to leave to Nyamira, or I'll continue with the submission. Because if a question of law has been raised, a preliminary objection of law, that these proceedings, there is no jurisdiction to entertain this matter. Because the matters are active in a court of law. Then we reconstitute ourselves and close our ears and close our eyes and see. A good case you have against the governor being thrown out at technicalities. Reconsider and let the matters be determined, that those matters that are in the High Court, let those matters in the magistrate's courts be determined, let those matters in the Court of Appeal be determined, bring a proper motion, remove your governor, because that is your right. It cannot be taken away by anybody. It is protected by 55 million Kenyans who passed the Constitution on the 27th of August 2010. It goes further and says in paragraph 5, notwithstanding the standing order, the Speaker may allow reference to a matter before the House or a committee. The Speaker can only have a reference or a citation. So the question I'm pushing ahead, and my colleagues are pushing, is how did this motion of impeachment pass the threshold for it to be in the order paper as a subject of discussion? It was an error, and we simply agree that that error is not fatal. We stop this matter until when the law allows you to remove the governor. It is your right. I'm telling you, it is your right. Some of the matters my good friend Mutuma will raise are filed by the assembly. Can we move one step further? Second question. The question about public participation. A report has been tabled. a report has been tabled. When you look at the standing order 68, look at it, standing order 68. It says the accused person needs to be given at least, and it is shall, 2 hours to read, to update herself, to instruct his counsels on what to answer. That report is only known to others, not to the person accused person. Is that the order that we need to be given that report? Look at it, at least 2 hours. We take instructions from the governor. We respond appropriately. Third issue on question of law. What does the law say on where public participation is supposed to be done? Is it in the sub-counties or is it in wards? Is there any elected or nominated member of the county assembly representing a sub-county? As we are here, all of you represent wards. Public participation is ward-based. It is not administratively based on the national government. It is an election generated mechanism that allows people as constituted in the elective positions, elective places, they make decisions based on the wards. By identification of them being voters in that ward, being beneficiaries of government services from the county government of Embu, of Meru, to those wards. There is no national member of parliament here who represents a constituency. And that is why we are saying we needed to have that report and tell it that it is not proper. The public participation, if ever it was done on a wrong path, on a wrong locality. Lastly, on a question of law still, who was the public participation targeting? Look at the summons. The summons are in regard to a person called notice of motion for the removal of the governor Meru County, Honorable Bishop Kawira Faith Mwangaza. Who is that person? When my brother stands and gives you the documents of the true name of your governor, you were present. You were present when she was being sworn in by the judiciary. There was nobody sworn in by the judiciary called Bishop Kawira Faith Mwangaza. We have the judiciary certificate here. It is public knowledge. You have the deed poll that was sworn way back in 2012. Change of names. Public participation was done for a stranger. My full names are Dustan, Omari, Mugak. If you do public participation for Evans Omari Dustan, that is not the governor. Are we properly here with the right person being the subject of this investigation? Those are 4 critical legal questions that I have very firm instructions to seek a ruling from the Speaker, whether technically and legally we are properly constituted and ready to do business of the removal and defending the removal or defense of a stranger. Honestly, we cannot impeach a stranger called Frida. We can't. That Frida has never taken an oath of office as the governor of Meru. That public participation was targeting a stranger, total stranger. And that is why the standing orders cannot allow me to sit there. I'm a stranger. You have reserved these for strangers. How do you discuss a stranger? Those 4 points, I'll allow Mutuma to reinforce them. Mwenda, on those issues of law only, Mwenda can produce the documents so that the Speaker gives a ruling. You have a good case. You have a good case. A fantastic case. A fantastic case. But procedures and the rule of law cannot, shall not, will not be bent under my watch. I will not. And I've given those 4 points to show that the safeguards, the midwife of every legal process is the law and the law of procedure. Otherwise, if we do not follow procedure, then we will not be. You know, Mr. Speaker sir has even told me that I can come and contest to be a member of parliament or an MCA from here because my blood is here. If I'm coming to contest in 27, let me contest when we have upheld the law.
Omari, please give Omari a bottle of water.
A bottle of water.
Yes.
Thank you.
You
I've done tremendous. I've done tremendous work. It's only that they cannot clap for me because they are my friends, all of them. We are even taking photos. I have nothing personal. But the governor should go home pursuant to the laws of the Republic of Kenya. Not any shortcut. For now, let us deal with the question of the process. Mwenda, you know you are a son of this area. Go slow.
Yeah, thank you, Omari. Mwenda, you can proceed.
Thank you. Thank you so much, Mr. Speaker. I'm Mwenda Kenyan, and I'll proceed from where our senior Omari has just ended. What we are saying is this is a very emotive motion.